So, in trespass, we talk about negligent and intentional acts that cause injury. In this harm, it must directly interfere with a person or property. And there's no lawful justification to you having done that. So trespass isn't just the unauthorized entry into someone's property without permission, because limit it to land and goods. Trespass, rather, is where that negligent and or intentional act causes injury to another. And the term injury is a violation of one's right. It does not mean physical harm or loss. So you need to understand that injury you have been caused may not be physical. Like in trespass of land, you have not been harmed physically. But in battery, that is physical injury. So for trespass, it allows the use of injury to denote the two. That someone was negligent and they made an intentional act that went on to cause injury to another person or his property. The key trespasses that we look at: trespass to land, to person, and to goods. So we start with trespass to land. And we highlight the word possession because this occurs when a person's possession in land is wrongfully interfered with. Note that we don't just talk about ownership, but your possession. Because you can be a tenant. A tenant does not own the land, but a tenant possesses the land for the period of that tenancy. So for trespass, he would be the one injured, not the owner. And we have three elements: entering, encroaching, and remaining. So when you wrongfully enter, you put your hand through someone's window, you walk. This habit of forming pathways in people's lands, the land has not been fenced, and you find it easier, instead of going around, you make a path across it. That is trespass. We also talk about remaining. Remaining on the land, that is, you had permission to come. You had permission to be here. I have welcomed you into my house. But when I ask you to leave, you fail to do so in a reasonable time. You tell me, no, I have nowhere to go. Let me leave tomorrow. But I have the right to ask you to leave today and to leave right now. So when you insist on staying without my express authority, you're trespassing. As long as you remain on this land, or as long as you remain in my house, yet I have continuously asked you to leave, you are trespassing. You also trespass by placing things on the land. And this is different from a nuisance in that, you see, in Rylands versus Fletcher, we talked about you introducing something and it's taken to be a nuisance. Because if you had not introduced that which was not natural to that land, then probably the flooding would not have occurred. So this trespass is different in that when you place something directly on the land and it affects the plaintiff's possession, you see, nuisance affects how someone enjoys the property. But in placing, you interfere with someone's ability to use that land. And this probably could be when you dig trenches to allow water to pass through your neighbor's land to your land. You're placing things there. And trespass to land is actionable. That is without proof of injury. You see, nuisance, as in the Rylands versus Fletcher case, it had the water overflowing into the neighbor. That was the proof that you have introduced something foreign. But in this trespass to land, I need not prove any injury. When I tell you to leave my house, yet you've done nothing wrong and you are not taking up any more space, I don't need to prove that your staying in my house has annoyed me or affected me. That asking you to leave is enough. But what are the defenses in trespass to land? One is prescription. And this is when a new owner you acquire. You talk of common grazing land or the right to use a road. The plaintiff would rather not have it. But you acquire the right when you buy an adjacent piece of land. And the plaintiff may not want the road to pass. Maybe you that came later, you found a house had already been built. And the plaintiff wanted the road to pass behind his house. You've bought a piece of land and you would prefer the road to be on your side. There is no action in trespass. You as the new owner, you also have rights. And that is your defense. You did not encroach on your neighbor's land to have the road. We also have an act of necessity. As we have said, as George was asking. That entry, when you see there's a fire and you enter that land without any permission, but you're entering to put out that fire, you no longer classify as being a trespasser. You acted to deal with the fire that was happening. Again, statutory authority. We've talked about the railway line and it being built next to your land, or even they acquire the land and the noise that comes with it. So what are the remedies in trespass to land? They include damages, where the plaintiff may recover monetary compensation, and the extent depends on the value of the land. Damages when government wants to build that railway line across your land, they will compensate you. And this compensation will be according to the value of the land that you own. Number two is action for recovery of land, where there has been a wrongful dispossession. Case in point, we went to buy land. I lost my title documents. The person selling decided to sell off my land as well. I can take them to court to forcefully move you out of my land because I had no intention of selling the land to you. So I go to court. I plead my case that I want my land back. And if the court so wills it, that one is considered done. we talk of ejection. And that element where you have come to my house, I have asked you to leave. You have refused to leave. Then I can forcefully remove you. But I can only use reasonable force. Because again, if I use excessive force, it becomes assault. So I will eject you from my land, having asked you before to move and you refuse to move. We also talk of injunction, and this is to ward off a threatened trespass or to prevent the continuance of an existing one. These are creating roads on people's land. So you go and you say there is no through way. You stop them from continuing to do that, or you stop them from those who may want to do that. So we talk also about distress, damage, feasant, and what is this? Where you place things, in the case of trespass by placing things, and this is placing of things, what should have come to mind is when grazers have come, they have found a piece of land, they are not aware who the land belongs to, they are grazing their cattle. So what is the defense when I find cattle grazing on my land? I have a right to detain those cattle. Since they are the cause of this trespass, then myself as the owner of the land, whatever you have placed on my land, I will detain them for causing damage and for infringing on my rights. So those are the remedies available. The trespass to land. Now we talk about the trespass to the person. It occurs in 3 ways. That is assault, battery, and false imprisonment. So we'll start with assault. And this is where a person intentionally threatens to use force against another person without lawful justification, therefore putting the person in fear. So when you come up and threaten me with a gun, you're not a policeman, I have done no wrong in as far as I can tell, it will be considered assault, where there's some apprehension of contact. So it's not enough for you to point the gun. You must also try and rough someone up. There must be contact. There must also be a means of carrying out the threat by the defendant. Is this defendant, 1, is the gun real? 2, does the defendant know how to shoot? You see, a toy gun cannot carry out the threat of that act. Those plastic guns, those wooden guns, they cannot carry out the threat. So we talk about this tort, it's generally associated with battery because of the element of the physical contact, and mere words without body movements do not constitute assault. So if someone is across the road and is brandishing that gun, you're not even able to tell whether it's real or not. They have not aimed it at you. You see, aiming is body movement. I have set a target. You're my target. But where I'm just across and my gun is in my holster, then you cannot say, I have assaulted you. They must coordinate. And assault is constituted by a display or show of force. Cursing in a threatening manner, where you use loud voices to try and intimidate a person, it's considered assault. Then we also move to battery. And this is the actual use of force towards another person without lawful justification. The reason we use lawful justification is that the police are allowed to use reasonable force to contain you. But when you wake up and go hit a person, what is the reasoning behind it? And the two tests are that, one, there must be an intention. An assault is committed where the plaintiff apprehends the commission of a battery on his person. So where the defendant does not intend to commit a battery, but induced a belief in the plaintiff's mind that he is about to do so, he's nevertheless liable for that. And we are talking about pointing a gun. Even if it's unloaded, you have no way of knowing that the gun is unloaded. It's not loaded. So it will cause you harm. It's still assault. We talk about apprehension. This test is based upon the subjective intention of both parties. Therefore, there is battery if the defendant intends to create fear of commission of a battery, whether or not he knows the plaintiff to be a fearful person, and the plaintiff actually has this fear. So it doesn't matter if I am afraid of guns. It also doesn't matter what I am afraid of. If you intend to intimidate me using this gun and you succeed, then you are liable. So in Smith versus the Superintendent of Working Police Station, the defendant was convicted of a criminal assault when he entered the grounds of a private house and stood at the window, seriously frightening its occupant, who was getting ready for bed. The plaintiff must, however, apprehend a battery. Thus, it's not assault to stand still at the door of a room. It would also not be assault to falsely cry fire in a crowded place. You see, when you come, find people, maybe, take for instance, at the entrance of a mall or at the entrance of, and you shout fire and people scatter, it ceases to be a trespass to the person. So must damages be proved? Assault and battery are actionable per se. That is, when the defendant's act have caused no damages, the courts may only award nominal, but aggravated damages may be awarded because of injury to the feelings. So this one is unique in that you may not have caused me harm, but you have hurt my feelings. Therefore, the law provides I will be compensated for that. So what are the rules that in battery? One, there's no consent for you to be that near the person. And a contact caused by accident over which the defendant has no control is not battery. When we are climbing up a flight of stairs and your shoulder is hit by another person climbing down, he had no intention. And he had no control over the number of people that were going up and down. It was by sheer coincidence that you're both going up and down. So it's not battery. And we have talked about contact. Touching another person in anger. You see the way someone comes up to your face and wants to shake you to put the so-called sense into your head, and they seem to think that you're not getting their point. That constitutes battery. The last trespass to a person is on false imprisonment. And this is depriving someone of their freedom without legal explanation. That is locking someone in a room. And the plaintiff, knowledge of the restraint is not necessary to the plaintiff, but it may affect the quantum of damages. We also have the intention and directness. And this is to exclude negligent imprisonment of another person. It needs to be committed intentionally and directly. And the restraint must be complete. That is, your freedom must be curtailed for it to work as false imprisonment. You're not able to go where you normally go. You're not able to do the things you normally do. Your movement is severely restricted.